Is the application of the political question doctrine sufficient to trump international human rights? It is in the U.S. court case of Schneider versus Kissinger, which draws a distinct line between international and U.S. law and justifies murder through state interest. About 40 years ago, Chile experienced its very own September 11th, one that destroyed its elected government and its people. Months following the violent coup on September 11, 1973, the military juntas killed around 30,000 people. But 3 years prior to the terrorism, General Schneider was one of the first victims of the Cold War in South America, kidnapped, tortured, and murdered on October 22, 1970. Commander-in-Chief of the Chilean Army, and disinterested in the CIA plan to overthrow Allende, he was not only eliminated, but his death remains justified today by the U.S. judicial system. The late general's 2 sons brought suit against the U.S. and Henry Kissinger the very day before the U.S. September 11th in 2001. Regrettably, the U.S. Court of Appeals in the District of Columbia dismissed the complaint on June 28, 2005, deeming questions of political and foreign policy out of judicial bounds. The Schneider case proves the isolationist tendencies of the U.S. courts today in the face of international law. In this travesty against the Schneider family and the Chilean people, the sovereignty of the U.S. wins against any notion of the preservation of human rights.